grant her permission to appeal in the matter of Barclay and another and Secretary of State for Transport and another.
Yes, good morning. Sorry we've kept you.
My lord, not at all. So may I just check with the court? The court now wishes to hear Cagney's application.
Yes, was there something else you had in mind?
Well, no, I was just wondering if the whole Barclay team is here.
Well, that's very good of them, but
Yes.
we said yesterday that we didn't need to hear any further submissions on the Barclay application.
Ah, okay. So Barclay is effectively discharged for today?
Well, it's up to them as to whether they stay or not.
Ah,
But,
okay.
shall we get on?
Yes, I'm very grateful. Also, may I say, just also by way of housekeeping, differently from yesterday, thankfully Miss Chalaby's case in the High Court in Cardiff finished early, so she is able to join us. So Cagney is represented by myself, Dr. May and Miss Chalaby. And then in line with the request from the court yesterday for enlarged versions of various documents. My lord, we have tried our best, but these documents, we understand, are intended to be viewed electronically.
Okay.
So even when they are enlarged...
Can I ask a question?
Yes.
When you read them electronically, can you read them?
Yes.
Okay.
Yes. Yes.
I'll do that.
So what we've done is just enlarge...
I don't think, thank you for trying
Okay.
this. Thank you. Mr.
Well,
Thank you.
I'll come back for the decision, as it were, but...
Well, we're going to obviously reserve, so don't
okay.
expect an oral judgment. I'm sorry. Thank you. I'm not sure I can read this, but...
No.
But
I mean,
thank
we've
you.
enlarged the most important bit. We've enlarged the whole thing, and then the other...
Oh, I
thing is
see.
not-
And that's the top left corner.
Yes, exactly. That's the top four.
Thank you for doing
bits.
that. That was one of the pages. There was another.
Yes, and then, on the A3 version, on the back of the A3 is
Yeah.
the other page. Also not great, but maybe a little bit more legible.
Yes, maybe, but otherwise electronic.
Yes, otherwise electronic.
Thank you.
Positive mode.
Thank you very much.
Well, Lord, I'm very grateful. So, with that small preamble, by way of introduction, as this court is very well aware, the test at permission stage, the question to be answered under CPR 52.61, is whether the grounds of appeal have a real prospect of success.
I think we do really know this. We can
Yes.
pass over this.
A realistic as
Yes,
opposed
we
to
can
a
pass
fantasy
over this.
prospect. And my submission is that Cagney's case, all four grounds of appeal reach that threshold,
Yes.
and that's what we will ask you to find. I will address the first three grounds. I will take them out of numerical order.
Right.
I'll address ground 4, then ground 3, then ground 1. And it's a time issue. Ground 4 will take the longest,
Yeah.
then ground 3, then ground 1, and then Dr. Lane will address
Thank you.
ground 7.
Lovely.
So let me begin by ground 4. Ground 4 can be summarised in 8 propositions. 1. Gatwick chose, in its environmental statement, to use the high ambition trajectory and the high ambition scenario assumptions on which it is based to quantify the extent of greenhouse gas emissions that would be caused by the additional flights as a result of the project. So, the environmental statement assumed, for example, that the take-up of sustainable aviation fuel would be 10% in 2030.
So let me just catch up with you.
Yes.
Assume, sorry, SAF
Yes.
would be 10%.
10% by 2030, 22% by 2040, 50% by 2050, and that zero-emission aircraft would begin commercial flights in 2035, and indeed be 27% of the ATMs by 2050.
27% of ATMs for 2050.
Yes.
Thank you.
Those specific numbers influence the projected extent of additional greenhouse gas emissions from the proposed project
That's the same point.
over the specific years, yes,
Yeah.
over those specific years of Carbon Budget 6. And neither
But
the
just so
sectors...
that influenced
The extent
CBC.
of greenhouse gas emissions from the project over the specific years of Carbon Budget 6.
Oh, I see. Right.
Neither the Secretary of State nor GAL disagree that that's what happened.
Okay.
Point
That's the
two.
high. That's the high ambition.
Yes.
Good.
quantify the extent. Point 2, the Jet Zero strategy was also relied on in other ways to contextualise the emissions, to stand in place of a cumulative assessment. That's particularly important. To assume long-term...
Let's have that one again.
Yes.
Sorry, to contextualise emissions and...
Yes.
Then...
To stand in place of a cumulative assessment.
Cumulative with what?
Cumulative with other airport development.
Thank you.
And to assume long-term mitigation of otherwise unmitigated impacts. And that use is again agreed.
To assume long-term mitigation, I think you said.
Yes, of otherwise unmitigated impacts.
I think I've caught up with you.
I'm grateful, my Lord. Third, those specific choices meant that information calling into question the cogency of those assumptions from the Jet Zero high ambition scenario, and thus the trajectory, was obviously material to the reliability of the environmental statement and to the fulfilment of the Secretary of State's Regulation 21(1) duties.
So it's obviously material to 21(1), and the other factor was...
The reliability of the environmental statement.
Yeah. Feeding into that.
Yes.
Good.
Fourth, the Secretary of State had such information produced by her own department. The Policy Commission return and the updated modelling for Jet Zero 1 year on. Fifth, the Secretary of State should have taken that information into account when considering whether Gatwick's methodology was cogent and deciding on the reliability of the environmental statement, pursuant to her Regulation 21(1) duties. Six, the Secretary of State didn't do that. In fact, these proceedings have clarified that she closed her mind to that information.
Well, does that add anything?
Yes, she apparently took the view that she could not consider, so not just that it wasn't relevant.
But the first proposition would be enough on your case.
Yes, she closed her mind to the information, but it's important why she closed her mind. She says that she could not consider it because, per the global feedback decision, that information was a matter for a different Secretary of State. The Secretary of State for Energy, Security and Net Zero, not her.
Where do we see the Secretary of State saying that?
I'll get them, my Lord.
Well, I hope so.
7.
Because I don't remember this point in the skeleton. But,
Oh, absolutely.
but I know they rely
It's the key
upon...
point in this
Let me
case.
finish.
Sorry.
I appreciate that they rely upon global feedback, query whether they're right to do so.
Yes.
But I hadn't got as far as appreciating that they thought that global feedback prevented them from taking it.
Yes,
Okay.
thank you. 7, and this is the key place where the High Court went wrong.
Right.
Global feedback is not an answer to this ground.
Yes.
It is wrong in principle to interpret global feedback as limiting the purposes for which departmental information produced by the Secretary of State for Transport to assist the Secretary of State for Energy, Security and Net Zero, or to update the Jet Zero strategy, can be taken into account by the Secretary of State for Transport. the fact that this information might be relevant to the Secretary of State for Energy Security and Net Zero's compliance with his, well, his Section 13 duty is irrelevant as a matter of principle to the other reasonable purposes for which the Secretary of State for Transport may be required to take account of that information. 8. The Secretary of State and the interested parties' other response to this ground, i.e. that the Jet Zero strategy and the Secretary of State acknowledged the extent of delivery or the existence of delivery risks, and Jet Zero strategy has a review mechanism.
So let me get that down.
Yes.
The other response, that
Yes.
the Secretary of State acknowledged delivery risks
Yes.
and the review mechanism
And the review mechanism is also
in the Jet Zero strategy. Is that
yes.
right?
Yes, the review mechanism in the Jet Zero strategy. Those answers are no answer to the ground. In fact, they cause more problems for the parties opposite.
Okay.
And let me just explain why. Say that more SAF were needed over the next decade, but take-up was slow. And so the Jet Zero strategy is
Do you mean future take-up?
Yes, future take-up. So future take-up over the decade is slow.
Yeah.
Right? You need more, but future take-up
When we
is
get
slow.
there.
Yeah, when we get there.
Yeah.
Yeah, so this is all about what's happening as we project forward in time. And so imagine on the Secretary of State's case that the Jet Zero strategy is updated, and then SAF take-up is really good under Carbon Budget 7.
So it gets better in carbon budget, so.
Yes.
Yeah. Thank you.
That would not assist with what happened here in the environmental statement. Because had those revised numbers, whatever they were, been used in the environmental statement, that would have resulted in higher volumes of greenhouse gas emissions over the crucial period throughout Carbon Budget 6, which would affect the level of significance against that carbon budget and would be worse.
I think I get the short point.
Yes, it would be worse overall for the climate.
It
greenhouse gas
doesn't
emissions.
assist on CB6, it would assist in a later period.
Exactly.
Yeah.
And so the review doesn't help with the specific numbers and the quantification that result from them, that were relied on.
Because the numbers in the
Yes.
ES related to CB6.
Correct. And the numbers of the ES, yeah, exactly. And furthermore, and this is it's somewhat of an irony, there was a relevant review of the Jet Zero strategy. There was Jet Zero 1 year on, where the Secretary of State's department used updated modelling. There was a review. There was new modelling. But the Secretary of State nevertheless refused to consider that and did not require GAL to update the environmental statement.
So that review was prior to the September 2025 decision.
Yes, it was all before the Secretary of State when she made her decision on the development consent.
Your submission there is that she
Yes.
did not require the ES to be amended to take that into account.
Correct. Or didn't. There might have been a number of things that the Secretary of State would do with that information. Maybe update the ES, maybe say that it's
Yes,
fine.
I'm just trying to get
Yes.
down what you were saying.
Yes, so that's what I said. But the legal point is, similarly with the Policy Commission return, what the Secretary of State did was say we can't take the new modelling into account. Global feedback. That was the answer.
In relation to...
The environmental statement.
But
And
it
cumulative
sounds as
effect.
though the legal duty you're actually tilting at is the duty in relation to the environmental statement, not simply a wider public law duty to take into account material considerations.
I think it's both. But the duty in the environmental statement crystallises.
It's only material because it may affect the environmental statement. So
Correct.
in fact they're related.
Correct.
They're all related to the environment duty to provide an accurate environmental statement.
Absolutely so. And that's why all of the noise around this ground about, all DCOs are going to be ad hoc reviews of the Secretary of State's policies, that's just not right. It's only if the environmental statement does what this specific environmental statement did, and there's additional information that shows that those projections are questionable, that we would be in this circumstance. This is a narrow point.
So I've got down, the error was that there's no requirement for the years to be updated, but you went further than that and said that the Minister took the view that the new modelling
Yes, Jet 018.
accompanying 1 year on
Yeah.
couldn't be taken into account.
Yes. Global feedback. It was a matter for a different Secretary of State.
So it's similar to an earlier point you were making on global feedback at point 6.
Yes.
So at some stage I need a little bit of education as to where that is in the papers when you're ready.
Yes. Yes, the Secretary of State repeatedly says it's a matter for a different Secretary of State. Global feedback dictates it's a matter for a different Secretary of State.
I've raised my question on that
Yes.
already. I'm not going to keep repeating myself.
You only need a manual reference. I think it's paragraph 47 of the Secretary of State's High Court skeleton, I'm told, is where it's made very clear initially, and then...
Well, I'll confess, that's, in the plethora of documents in this case, that's one document I'm not getting. But
Yeah, it'll be in the Cagney core bundle.
But that's a submission of
Okay.
counsel. I mean, what I'm interested in is whether the Secretary of State was taking that view at the time of the decision.
Well, the decision letter doesn't help us.
I mean, counsel
because it
say,
doesn't...
I'm sorry, counsel say all sorts of things.
Yeah.
What's the issue? The issue for this court
Wow,
is
money.
what is the issue for this court is what did the Secretary of State do?
Yes, well, I mean,
And is this a pleaded ground?
Yes.
Well, I understand that you take the view that global feedback is not an answer. I grasp that.
Yeah.
But have you taken a point in the pleadings that the Secretary of State misdirected herself because she took the view her discretion was constrained by global feedback?
Yes.
Okay, well, I'm sorry if I've missed that, but I just need that pointing out at some stage. Convenient.
Also, if the Secretary of State's counsel on instructions explain the Secretary of State's approach to a matter that wasn't addressed in the decision letter at all, so the only explanation we have is via these court proceedings, then I think that's...
Well, so you say,
reliable.
I need to be persuaded.
Could I have the reference again, please?
So it's core bundle, page, so CB 295, paragraph 47.
7. Yeah. Is it dealt with in the witness statements for the department?
My lord, probably is what I'll say. I recall there being stuff in the witness statement relevant to this, but I didn't
well, that
want
way
it for today's hearing.
we would be helped on that too.
Okay, so can we have a look at the witness statement?
Thank you.
Thank you very much. But, I mean, as your lordship says, the key point in this ground is that the Secretary of State closed her mind to the information. She thought it was a matter for a different Secretary of State. And she relied on global feedback for that. Sure, we've said that she specifically said she couldn't take it into account. Find the letters is what we've said.
We can come back to that.
So, I'd like to start, please, in global feedback, given how
Yes, please.
crucial it is to this ground. So that's in Authorities Bundle 2, tab 30.
Can I have a page reference?
Yes, I'll start by bundle, tab, and then page.
Yeah,
That's
well,
okay.
tab's no use.
Yes, I'm no
tabs-
use to you. I'm very aware.
That's
1083.
Thank you.
So 1083. This is paragraph 1, and that clearly articulates the question that was in issue in global feedback.
Yeah.
So it was a Section 13 challenge in relation to the food strategy. There is no Section 13 challenge in this case.
Obviously, yes.
1084, by letter, so next page,
Paragraph 6.
paragraph 6 by letter C, identifies the particular question that was then formulated to be asked to be answered in the case. And that question, and we see this at paragraph 10, also by letter G, is that the question was answered in the negative.
Yes.
Now, the court then, in the next few pages, reviews the Climate Change Act, and then they set the factual and legal background out. You're very familiar with this, 1084 to 1096, including case law on the meaning of the Secretary of State. So can we go, please, on to paragraph 70, 1094.
Thank you.
Not quite. 1096.
Yes.
So in paragraph 70 onwards, the court applies the meaning of Secretary of State to the Climate Change Act, and then over the page, paragraph 75, 1097, we get to the key bit relied on by the parties opposite. Indeed, paragraph 75 was the only...
It's a short point that what this case decides is that the Secretary of State in that statute refers to the Secretary of State responsible for...
Energy and net zero.
Yeah.
The duty falls on the Secretary of State for
Yeah.
energy and net zero, not on any other Secretary of State. Correct. That's the effect of section 13. Paragraph 75 was the only paragraph of global feedback relied on by the parties in writing below.
In the skeleton.
Yes, so I can give you the references for that. Just the references, please. Core bundle,
Yeah.
293, paragraph 43, and 315, paragraph 41.
29541. Thank you.
Now, in oral submission, the High Court was taken to further paragraphs. That's on 1098, paragraph 84.
Yeah.
That's the piecemeal or multi-partite approach to the performance of the duty. That was
Advocated by Dr. Wolf.
advocated exactly for Dr. Wolf. And the proportion of the share. And the judge in his judgment actually excerpts paragraph 80 to 84. But I'd like the court to turn the page over
Yeah.
and please read paragraph 85.
Right.
So it's clear from that paragraph, first of all, there can be sector-specific policies, like Jet Zero 1 year on, and these sector-specific policies are not impeded by the provisions of Part 1 of the Climate Change Act. Paragraph 85 addresses the Policy Commission returns process, makes clear that that too is not impeded by Part 1 of the Climate Change Act. It's not subject to any statutory procedure and is discretionary, and a policy return is not a Section 13 policy. And we rely on this because all of those processes, not impeded by Part 1 of the Climate Change Act 2008, are undertaken by the Secretary of State subject to her normal public law duties and any additional duties that apply by way of the EIA.
So the short point is, if there is a public law duty to take into account the return,
Yes.
that analysis is not altered by Section 13
Correct.
of the 2008 Act or what was said in global feedback.
Correct.
I think we understand your point.
I'm very glad. My
Not saying what I think about it, but
the
certainly got the argument.
secretaries, well, what we say about that argument is that it reaches the threshold for permission. Paragraph 90, page 19 of the Secretary of State's skeleton, paragraph 44.
This is the skeleton before
Skeleton
us.
now, yes, the
Yeah.
Court of Appeal skeleton.
The one we haven't read.
Yes, I'm very grateful.
Sorry, just let me catch up with you.
Paragraph.
Paragraph 44.
Thank you.
Yes.
So this is where global feedback is articulated to be highly relevant. The Secretary of State relies on the separation of responsibility, the respective roles, She says the Secretary of State for Energy and Net Zero has responsibility for compliance with carbon budgets. That's highly material to where the Secretary of State for Transport was required to investigate information.
Yes, that's the way I understood it, required to investigate, as opposed to prevented from investigating, which is how your new point.
It's not.
At least that's what they say.
Yes.
Do they put their case any differently from the High Court?
No.
No, okay, sorry.
I've got all the references, so I'll give them to your Lordship in a second.
Thank you.
But let me just finish this point. And they rely there in particular on the purpose for which the investigative information was created to help the Secretary of State for Energy and Net Zero comply with his duties. Now, we've just read paragraph 85. That makes absolutely clear that whatever that purpose might have been, it doesn't mean that they fall under the Climate Change Act obligations. And it doesn't mean that they are a matter for the Secretary of State for Energy and Net Zero alone, and not irrelevant to the Secretary of State for Transport's obligations and or analyses. So, references to where we have said this before.
Yeah.
Our Court of Appeal skeleton, paragraph 72.
Thank you.
Not entitled and or obliged. So not entitled to take into account and or obliged.
Let me just find that. Sorry, which line? Lines 3 and 4.
Yes.
Yes.
And then our High Court skeleton, paragraph 64.
Probably in a similar language.
Misdirected by misreading global feedback as exclusively for one Secretary of State. Oh yeah, the point about the wrong Secretary of State, so Secretary of State for Energy and Net Zero, not the Secretary of State for Transport, was in Jessica Matthews' witness statement, not in the excerpt in the bundle. So if you'd like to see that, we can get
I think
that.
we better have that. And in and at some stage, you better see it in the Statement of Facts and Grounds.
No. And it might be in the reply.
Thank you.
I'm just pausing to make absolutely clear that this articulation of the case is no different from the articulation of the case before the High Court. And having looked back at the oral submissions that were made to the High Court, and no pleading point was ever taken in that regard. And
Well, we're in this court now.
yes, and if the court is concerned that it goes too far, or that there's some pleading issue with saying that the Secretary of State's position was that she wasn't entitled to take it into account, then, as your Lordship pointed out, the case in terms of grant of permission doesn't need to go that far, because it's enough that the Secretary of State closed her mind to it, and that is very much the Secretary of State's case.
Well, that's why I tried to clarify with you what you meant by closing of mind.
She did not take it into account.
That isn't closing, and in public law, that's not closing of mind. Failure to take something into account, I understand that concept, we're all familiar with it. But when you added closing of mind,
Yes.
that seems to be aligned with the alternative submission that she could not take it into account.
My Lord, she didn't take it into account.
Otherwise, the expression closing of mind is something that we refer to in the law of bias.
Yeah, well, the Policy Commission return and the Jet Zero updated modelling for 1 year on was put in the box matters for the Secretary of State for Energy Security and Net Zero.
But she didn't close her mind to it, because she did make that decision as your submission. So she had it in mind, and then, as you've just described, put it on a different minister's desk.
Well, I'm not even sure that that's right. Because we've never, one of the problems with this ground, or the way in which it's been addressed, is that we've never really understood what it was that the Secretary of State for Transport actually did. The answer has been global feedback means we don't need to worry about this information. But we don't know whether, and that's why we've put all the ground in the alternative. If she had it before her, she didn't probably take it into account. If she didn't have it before her, she should have asked for it Tameside.
Yeah, we understand that.
Yeah, so that's why we put all the alternatives.
To assist,
we don't actually know.
The way this came about was that you asked for disclosure.
Yes, correct.
And this is not a matter tackled in the decision letter.
No, not for the Policy Commission return. For Jet Zero 1 year on,
Yeah.
that was raised.
Yeah, but
and
not the modelling.
The modelling was raised. Yeah, absolutely the modelling was raised.
What, the revised model?
Yeah, AEF asked for the revised modelling
Right.
and made a whole set of submissions in relation to it. And the Secretary of State said, not a matter for me, a matter for the Secretary of State for Energy Security and Net Zero. That's as I understand the Secretary of State's case. That's what I've always understood the Secretary of State's case to be. Not a matter for me. The Secretary of State's case, as far as I understand it, has never been. We took all these material considerations into account and decided that add in rational decision there. That's never been the Secretary of State's case. So, my Lord, in points kind of 1 to 3, I set out how the Jet Zero high ambition scenario and trajectory were actually used by Gatwick in the environmental statement. That was in the skeleton. I can take your Lordship just to 1 or 2 things to make it absolutely clear the extent to which it was used. So that's in the supplementary bundle. Agnes, supplementary bundle, please. Tab 10, page 113. At the bottom, your lordships will see 16.4.55,
Yeah.
which sets out where the modelling of future emissions has come from. And you see there at the second bullet point those SAF numbers that I referred to, uptake of SAF. And in the third bullet point, you see the zero emission aircraft matters. And so over the page, that is set out in tabular form, 114. You see the rows at the bottom.
So this is your submission 1.
Yes. And
Okay.
1 and 2. And then it's made very clear also at 141. That the numbers at the bottom, so that 6 carbon budget set of numbers,
Yeah.
factors in those assumptions that we have just seen.
That's what you'd expect if that's the way it's being done.
Yes, correct.
Yeah.
And that's also made very clear just a little bit earlier on,
Yeah.
page 132, paragraph 16.9.64.
I think you said this was common ground, didn't you?
Yes.
Yeah, so we don't need to take time on it.
I'm grateful. Then the cumulative effects header is 142.
142.
Yes.
Where do we look?
That's a good question.
Sorry.
I think you want 143, don't
I'm
you?
very grateful. I do want 143. Cumulative effects header, 16.10. And 16.10.6, that's where it explains that the Jet Zero strategy has stood for the cumulative sectoral assessment of the aviation sector.
Yeah. So, in simple terms that I can understand, what's in the modelling used for the JZS
Yes.
was used to represent cumulative effects for aviation generally.
Yes, correct.
As a context for this project.
Correct. The specific numbers. So Gatwick will be X.
Yeah, okay,
Heathrow
got
will
it.
be Y.
We can move on.
Yeah, exactly. The specific numbers. That's important when we get to what Jet 01 does. So just pausing here. So Gatwick, in its opening 9 paragraphs of its skeleton, on this ground, that's pages 13 to 15, spent quite a lot of time saying that it was open to them to use the numbers in the high ambition scenario in this way. And Cagney's never taken issue with any of that. Obviously, it's open to use the numbers in this way. But as with any other set of assumptions used as a basis for an environmental statement, if later information calls that into question or raises issues that might need a refresh, the same applies here.
What applies?
So as with any other set of assumptions for an environmental
if
statement,
later information calls into question the
calls
assumption.
into question the assumptions in the environmental statement,
Yeah.
then that's relevant to the cogency of the ES.
Okay.
It needs to be taken into account. And Gatwick cannot insulate itself by using the projections in the high ambition scenario and then saying that any later information produced by the Secretary of State for Transport is irrelevant to the environmental statement, or can't be looked at because that's a matter for another Secretary of State, or shouldn't be taken into account, or is not material, however they put it.
You've made this point.
I'm very grateful. So the Secretary of State accepted the approach, and we gave all our references in paragraph 66 of our skeleton, page 17. One particular one, just for your note, in the common bundle.
Sorry, let me just catch up. You're on the skeleton page 16, did you say?
Page 17, paragraph 66. Gives all the references in the decision letter. To where the Secretary of State addressed this. A key one that we rely on, there's loads, but the key one we rely on in the common bundle, page 162, it's decision letter 166. Decision letter 166. There the Secretary of State says she's taken into account those concerns about uncertainty, and that includes the AAF submissions about Jet 01 year on. But the view is that there's robust, there's mechanisms to review, and consequently, and this is the key bit, there's no reason why the weight given to the Jet 0 trajectory should be reduced, and the policies must be considered to be consistent. And in my submission, there were reasons why the approach taken to the use of the Jet 0 trajectory was questionable in the environmental statement. There were reasons that the Secretary of State's own department had produced. Just a brief refresh in the authorities bundle, please. Bundle 1.
But again, just to show that I'm not understanding this.
Yeah.
At that point in time, obviously you didn't know anything about the returns.
Correct? Yep.
Or the other source of information which you rely upon in your skeleton, the updated modelling.
The updated modelling was known about at that point.
It
and
was.
put before the Secretary of State.
And you made submissions about it.
And we made submissions about that.
Okay.
The policy returns we didn't know about.
Yeah.
That came out as a result of the disclosure here. But the evidence of the Secretary of State is that
the updated modelling is in the common bundle, I think, or the your core bundle. Core bundle.
Might be in our supplementary bundle.
Okay.
The AF stuff.
But that second source was known about and
Yes.
submissions were made about.
Yes, correct. Yes. The what does it say? The Secretary of State's evidence clarified that at the point the DCO decision was being made, the Policy Commission returns that are before the court were in the Secretary of State for Transport's Department's hands.
Yes.
They were, so it was contemporaneous.
Yes, but I think the Secretary of State accepts that they weren't taken into account.
Yes. Yes. Yes.
I mean, being inside the department is not the same thing as being taken into. There's plenty of case law on that.
Correct. My lord, correct. And your lordship is right. That's as far as this ground needs to go for permission. They were there. They weren't taken.
So I've not said that.
Well,
that's your submission.
That's my submission.
Yeah.
Yes. In the range of submissions I have made, in a panoply of ways in which this ground.
You say that's enough.
That's enough, and that is certainly enough for permission to be granted. So.
Does that mean you're going to stop there, or?
Tempting, my lord.
No, I wasn't expecting you to say yes.
As that would be.
But I was expecting you maybe to move on.
I'm very grateful. In the authorities bundle, please, volume 1, tab 4, page 84.
Thank you very much.
Tab 4, it's the regs, page 84. Regulation 5.5 at the bottom reminds us that the Secretary of State, or the relevant authority, must ensure they have or have access as necessary to sufficient expertise to examine the environmental statement or any updated environmental statement. And then further on page 86, there's the 21.1 obligation.
It's really 21 that you rely on.
Yes. I rely on Regulation 5 just to answer this point. The Secretary of State in the skeleton argument suggests that the DCO process is not the place for this type of expert analysis on whether the numbers were reliable or not. Effectively, that's the point. And my submission is that's wrong for two reasons. First of all, obviously the DCO process is exactly the right place for that. We do that all the time. Lots of expert evidence is looked at in great detail. But secondly, the Secretary of State has a regulatory obligation to have the expertise to do this, and then another obligation to do it. So that's Regulation 21.1c. B and C, reach a reasonable conclusion, take into account the examination of the environmental information, and A is examine the environmental information. And what we say is that what should have happened here with the Policy Commission returns and the underlying Jet Zero 1 year on updated modelling was that should have factored into the examination of the environmental information, and it didn't. So the Policy Commission returns. The judge had before him, well, our skeleton at paragraph 68 on page 17.
So we can put that away.
Yes, you can put that away, I'm grateful.
And we're into...
Our skeleton argument, page 17, paragraph 68. That sets out, and it will be well understood and known to this court in any event, the Policy Commission return process and how disclosure of the documents came about. The court is very aware. There was the evidence from the Secretary of State, from Jessica Matthew. There was the evidence from Mr. Delafield, who's the Deputy Director of Aviation Decarbonisation, evidence from Mr. Moran, and evidence on behalf of CAGNY, indeed from the Aviation Environment Foundation, Mr. Tim Johnson. And all of that was put in to explain what these Policy Commission documents show.
Well, Mr. Moran was dealing with a correction.
And was dealing with a correction, yes.
But he wasn't dealing with what you just said. But,
well...
But do we need to get into Mr. Moran? Good.
We don't. During the hearing, Mr. Johnson and Mr. Delafield liaised to try and agree some various points.
Yeah.
And for the purposes of the permission hearing, we don't need to go into detail in that regard because the key error that the judge made was the global feedback error. And all that I need to show for prospects of success on the underlying ground, I can show via two things from the Commission return. First, and this is why I asked you to look at the skeleton, it's over the page 18. First, A,
Yeah.
transport sector as a whole off track,
Yes.
and that's clear from the header from the Policy Commission return. And B, key delivery risks around SAF, and that was agreed in Mr. Delafield's table.
Is that the joint table with
Correct,
the column?
and I'll go there very quickly.
Yeah, I appreciate that. Thank you.
Yeah.
I mean, so far as the first point is concerned, it's the transport sector as a whole. So
Yes. Yes. So there's a
So-
couple of points to be made about that.
But you rely particularly on the SAF.
Yes, correct. Yes. So that, and a point is taken with the kind of the reference to the share, and the answer to that question is really in Jessica Matthews' witness statement, where she makes it clear. So this is common bundle, page 504. So it's tab 21, page 504.
Yeah. Paragraph.
It's paragraph 17. That was shown to the judge, where she addresses effort shares. In fact, I think the judge quotes this. And she makes the point 3 lines down that effort shares, even though they're not statutory, can be used for planning purposes, although they're not legally binding. Now, she doesn't mean planning purposes like technical planning purposes, but she does mean planning by the department in
Yes.
relation to
Planning in a broad sense,
actions.
not land use planning.
Yes, exactly.
Yeah.
Exactly. And this is in line with paragraph 85 of global feedback. Also, just to make clear, nothing in this ground relies on effort share being statutory or an obligation or anything of the sort. In fact, exactly as Miss Matthew describes, is what we rely on. So the cover note shows that there's an annual estimated gap of 20.9 million tonnes of CO2e.
Where are you reading from?
Share. So this is, just for your note, it's a supplementary bundle, tab 21, page 623.
But what is it?
So that's the cover note for the Policy Commission return.
Can we just have a look at that?
623.
Supplemental
Supplementary bundle,
tab 21.
623.
I think you mean 263.
Oh yes, I mean 263, I'm very
I was puzzled.
Yes, this is something I've.
It might just feel like it's 623.
Yes. No comment. And where on that page? Oh, is it point C?
Yes, it's point C.
But this is for transport as a
Correct,
of,
that's
all,
for transport as a
of all types.
Yes, yes. And I don't shy away from that point, it's for transport as a whole. So it's for the Secretary of State to understand the extent to which that affects aviation in particular. But she didn't take it into account, so she didn't do that analysis.
So and it's an increase of 3.7 compared to the March 2025 modelling.
Yes.
That's it. Okay. Yes. Where do we go next?
So next, we go to the Secretary of State skeleton to answer a particular point that's made that picks up something, well, this kind of theme. It's page 20, paragraph 48b. And this is where we need one of the documents handed up. So what's made there, the point that's made there, is that, well, international aviation and shipping are outperforming as against their effort share, and the reference there is SB 296. And the answer to that is twofold. First of all, SB 296, and that's the back page that's been provided. This shows international aviation and shipping sectors together. So it's not possible to know from that what is happening from international aviation alone.
Are you saying there isn't a separate line for aviation?
I'm saying that the Secretary of State can't rely on this as evidence that the position with aviation is fine.
Can I just understand this document? Because it doesn't appear to have a heading.
No.
So is this, where it describes a residual emissions profile, is what you're explaining is that's residual emissions profile for shipping and aviation.
International shipping and aviation.
International shipping and aviation.
Yeah.
And then it goes through the various forecasts in relation to the baseline abatement and then the residual pathway, which is then presumably what's plotted on the graph in the bottom right.
As I understand it, yes. Yes. And the Secretary of State relies on this as an answer. And the short point is it's not an answer because you can't know from this if aviation is fine.
Because you can't see it separately.
Yes.
That was the short point I put
That's
to
the
you.
short point, exactly. That's the short point. And the second point
But does the graph assist at all? There are four different colours. I can't. My Lord's eyesight is better.
Well, only A, since I had my cataracts done, and B, as a result of having my reading glasses. But unless I'm going to be corrected, I don't think it does help on that point because the plots are the aggregated figures from the charts.
Thank you.
Correct.
Assistant, sorry to interrupt, Mr. Moran does provide the figures in his witness statement. I can take you later.
Okay. So,
forward to
but
that.
the second and obvious, the key point is whatever it shows,
Yeah.
the Secretary of State didn't take it into account. She just didn't take it into account.
Because this, just help us again. I'm sorry if I'm being slow. This document is what exactly?
It's part of the suite of documents in the Policy Commission return.
Yes, that's what I was hoping you would say. For simplicity's sake.
Yes. So the SAF delivery risk is the next one, and as your Lordship is correct, that's particularly relied on. That was agreed. There's a few places, but the clearest one is in that table that Mr. Delafield and Mr. Johnson put together. That's in supplementary bundles, back in Cagney's supplementary bundle, please. Page 300, tab 26. And you'll have seen the way the table works is there's the Cagney proposition, the DFT response, and Cagney explains why it doesn't really respond to some of the responses, but here there's agreement.
So I'm just catching up.
Yeah, so it's row 6 on page 492, it's not 492, that's on page 600. And that's agreed, and the reference is provided. That's to the other document that your Lordship asked for in relation to being enlarged.
That's also to be seen on page, when we looked at it electronically, page...
It is 467.
of the...
That's supplementary bundle.
Thank you very much.
467.
No, that can't
That
possibly
can't
be
be
right.
I mean, on the document you sent us, it's 275.
There you go, 275. Oh, what, I meant 275. Yes, 275, and it's really those top two lines. If you zoom into the top two lines, you'll see that they deal with the increasing take-up of sustainable aviation fuel, and they set out why there's high delivery risk in relation to that. And they set out some scenarios in that regard.
Just educate me a bit. How is delivery risk expressed? Qualitatively or in some other way? By the use of words or numbers?
It's expressed in different ways in different parts of the document. So it's mostly by words,
Yeah.
but there are some numbers as well. So there's
was
numbers.
delivery risk assessed in the Jet Zero strategy itself?
Yes.
Presumably using similar techniques.
Yes.
Now, when I read row 6 of this helpful statement by the experts, the commission return template shows, etc., high delivery risk. Is that purporting to say that the risk in the return is different from that which had previously been assessed?
Yes. Yes. Yeah. Well, that's how we've always understood it. We've always understood that the point of this policy commission return is that it shows that those numbers, 10% by 2030, 22% by, that there is a high risk in relation to those numbers.
As the achievement of those numbers.
Yes, correct.
But my question is a very precise one as to whether that return was saying that obviously when those numbers were created in the first place, there was a risk over delivery. And the question is whether or not what the return is saying is that the nature of that risk has changed.
Yes. Yes. And the key thing about this return is that it says, in terms, more SAF will be needed more quickly. More SAF. So, given that there's a significant risk in relation to SAF and more SAF is needed, that has an impact, as per my previous example when I was going through the propositions.
Well,
about
if there's a reference on that
the
you
numbers.
want us to look at, then otherwise it's very difficult to take into account.
Yeah, so more SAF is in the document.
Yeah.
That was agreed.
Is that whereabouts?
So that's back on page 299,
Yep.
row 3. More emission savings from SAF.
Saying something slightly different, but there it is.
Yeah, so 3. Even if there's disagreement on
I've read
why,
it. We've read it.
yeah, there's more from SAF, and then Mr. Delafield has a kind of agreement with a bit more explanation, and by reference to the SAF mandate. So there's more SAF, and there's high delivery risk in relation to the SAF.
Well, more emission savings may simply mean the SAF has got to be more performative in saving emissions. It doesn't necessarily mean, anyway, we see what it says. There is, of course, a difficulty, isn't there, in the High Court and the Court of Appeal in going into technical matters like this, because insofar as there's the Lord Chancellor case, amongst others, with the judgment of Mrs. Justice Carsey there was, the court can't resolve these technical differences.
No. But whatever what the court does know is that the Secretary of State's response on this ground is not, this is all irrelevant.
No.
The Secretary of State's response on this ground is, it was not taken into account.
I didn't need to.
Yes, exactly.
Just for my benefit, this is a note of an attempted agreement.
Yes.
So, presumably, in that it's a note of an attempted agreement, there was not complete agreement.
There was not complete agreement, but there was an attempted agreement.
That begs the question then. So when one sees in the middle column agreed, those are things that were the subject of agreement, yes. Subject to, whereas if one looks, for instance, at the row 4,
yes,
not agreed.
Yeah, correct.
And then the alternative wording is presumably the basis of the disagreement.
Correct.
Yeah.
And where it's agreed or agreed in part, the alternative wording is the basis of the agreement in part. So, yes.
Sorry, say that again. Where?
So where something is agreed or agreed in part,
Yes.
and there's alternative wording from the DFT,
Yes.
that forms part of the agreement.
Well,
The
did you?
agreement
Are you
part.
saying that your expert then agreed the alternative wording?
Yeah, so if you look at row 3,
Yeah. Okay.
agreed.
Oh, I see. Yes. 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 Though we don't necessarily see that on item 4, for example, which is rather interesting.
No,
Because
but that's not agreed.
Yeah, that's true. Yes. Yes.
Okay, so
Well, there is an example. I don't want. There's no need to go through this detail. I know what's.
Well, this is why, as my lord says, the proceedings in the High Court, for that matter, this court, are not apt for seeking to resolve these disagreements.
Yes.
And nor do those disagreements necessarily always engage with the question of law.
no, indeed.
This material may engage with the question of whether, for instance, there's some argument about no difference, but I'm not conscious that that was the basis of the judge's decision, or
Correct,
was
it
he
wasn't.
engaged with those arguments?
Correct, exactly. And of course, I would make the point that had this information emerged as it should have, well, I don't actually need to say that. Let me go to J01 year on, which was before the Secretary of State.
Whereabouts we go?
So can we just go to one reference in the supplementary bundle, page 467. Oh, that can't be right. What am I looking at? I must be looking at High Court references.
We've only been blessed with 305 pages
Yeah.
in the supplementary
Yes.
bundle, so if you come up with a number north of 305, you're not
Yes.
going to help us.
Definitely not right. I think what's happened is, yes, I've turned pages around so bits of pagination don't look like the right pagination. So Jet 01 year on is in the common bundle.
Yeah.
There we are blessed with many pages. It might be here. Aha! 467 in the common
467.
bundle. Jet 01 year on, that's where the modelling is explained.
Now, how are we doing on ground 1?
So I've got 2 more points to make.
Because we need to finish the other grounds by about 12:30. Thank you. I appreciate this is technically quite a
Yes, indeed. And also we did start a little late.
Yes, I built that into 12:30.
Yes.
Let's
Well,
keep
we'll
going.
see how we do.
Yes, we will.
So this explains, J01 year on explains the modelling and how the modelling has changed on that page. This prompted AEF to ask for the updated projections in relation to Gatwick. You see that in the supplementary bundle, page 158 to 159. This is a submission, so this is tab 14 in the supplementary bundle, page 158 to 159.
So this is a representation by...
Correct.
By whom?
But this was a representation by AEF.
Right.
And this is their deadline 6 representation. It
Yeah.
explains how the modelling information for Jet 01 year on was obtained
Yeah.
and sets out what it means, including the bullet points at the bottom, that the forecasts approximately half, lower traffic forecast for Gatwick, so approximately half the emissions that were considered by the project. Over 100,000 emissions lower,
Because there's less ATMs.
because there's less ATMs.
So where does that take?
Well, it takes us to quite an important place. And if
Let's
your
get
ship
there.
takes up the skeleton,
Right.
our skeleton argument, page 19.
Skeleton page 19.
Yes, paragraph 70 to 71. So 70 at the top sets out, relying on the AF information.
This is the second piece of evidence.
Correct, it's Jet 01 you're on, modelling. It sets out what the difference is between the modelling for Jet 0 strategy that was used as the cumulative assessment and the modelling for Jet 0 1 year on. And then 71, in summary, explains why it's not a good thing for GAL and the environmental statement. So the new high ambition scenario and the new high ambition trajectory that's modelled under Jet 0 1 year on, they are based on lower growth at Gatwick than was being proposed by the project. And this throws out the Jet 0 strategy acting as a cumulative assessment. Put simply, new modelling demonstrated that the level of growth associated with the proposed development could no longer be considered to be compatible with the high ambition trajectory, because the high ambition trajectory now assumes a much lower number of ATMs for Gatwick.
Can I catch up?
Yes.
We're talking about the modelling for the JZS
Yes.
to take into account cumulative assessment.
Yes.
But this argument, this new piece of evidence,
Yes.
focuses on the projections for ATMs at Gatwick.
Of Gatwick, correct.
No impact on cumulative assessment insofar as other airports are concerned.
No, it changes. It changes. Well, I don't know the extent to which it changes
Well, that
numbers of
point,
other
isn't,
airports.
that point isn't before us.
That point isn't
No.
before you. What is before you
Is the lower projection.
the lower projections, exactly. And the lower projections had an impact on how the new modelling cumulatively understood
Well, there'd be a smaller component from Gatwick.
airport development. But not just that, but the smaller component from Gatwick fitted with everything else in the new model to show how the trajectory would be complied with, would be reached. But if the trajectory is based on the cumulative assessment on smaller Gatwick expansion, that's highly relevant to the cumulative assessment that Gatwick was relying on. It's a problem for Gatwick, but it's never a problem with which they have engaged. Because if Jet 0, if you're relying on this as your cumulative assessment, and your cumulative assessment now shows 100,000 movements less than your project is projecting, it can't be your cumulative assessment anymore. So if the old modelling has been overtaken, that means that there's at least some explanation that has to be given. But it wasn't. And it wasn't because they took the view that it didn't need to be.
So that was one of the points.
Yeah, that's the key point. Jet 0 1 year on is a cumulative assessment.
Yeah, we've got that. And then the other point which remains?
So the other point which remains is, going back to the judgment.
Yes, please.
So that's in Common Bundle, tab 10, page 295.
Paragraph.
So if we start with paragraphs 80 to 80, 295, give me a second. 295. So it's discussion and conclusion. So paragraph 294 starts with global feedback, sets out those paragraphs we looked at together this morning, but doesn't set out paragraph 85. Paragraph 295 then deals with Boswell. We've given our response to Boswell A12 in our skeleton argument, so you would have seen that. Then goes back to global feedback at 296. Kind of ping-pongs between global feedback and Boswell A12, and then the key analysis is really paragraph 300. The judge says that it was lawful and rational for the Secretary of State to proceed as she did. Not appropriate to interrogate the risks of delivery, because her department's policy commission returns were produced for a different purpose. He says, essentially under the aegis of the Climate Change Act, but that's really not, doesn't sit easily with Boswell, with global feedback, and paragraph 85. Also, in this paragraph, the judge isn't really engaging with the main point in this ground, which it's not just about kind of general reduction of weight to the Jet Zero strategy. It's about the specific impact that this information has on the cogency of projections, like the SAF projections, and on the cumulative assessment that was being relied on. And he says the same applies in 301. He says the same applies to Jet Zero 1 year on. So it's global feedback is the answer. But in my submission, and he then says, well, the NFU line of case law, which is if there's clear evidence that some other regulatory regime isn't going to solve your problem, then you have to take that into account. I paraphrase. Mr. Justice Mould effectively uses global feedback to limit the way in which that NFU principle is applicable. And that's not right. Just because information was produced which fed into the Secretary of State for Energy Security and Net Zero, that does not mean that the NFU line of case law is inapplicable to it. It's fully applicable. So finally, on the judgment, paragraph 303 at the very end gives the judge's key conclusions. But just to deal with a bit in the middle, Mr. Fleming submitted that the evidence of Mr. Johnson is relied on to seek to undermine extant and lawful government policy. And that's not right. That's not what this ground is about. It's about the specific robustness of the particular projections in the environmental statement, which information that this Secretary of State held showed were no longer robust. So for all those reasons, unless the Lordships have any questions, that's ground 4. It is realistic as opposed to fanciful prospect of success on that ground. My Lord, ground 3, CO2 emissions. A little summary of this ground 2, 5 points this time. First point, the Secretary of State herself identified that the applicant had not taken a precautionary approach. Second, the Secretary of State herself identified what the precautionary approach would have entailed. It would have been to quantify non-CO2 emissions. Third, the judge clearly erred in holding that the rational response to that state of affairs was given in paragraph 178 of the DL, that there is no established...
178.
DL 178.
Sorry.
No. That there is no established methodology for quantification where scientific consensus would guide quantifying non-CO2 effects in relation to a planning decision. That's what 178 says.
Right.
Fourth proposition, requiring scientific consensus in relation to an established methodology is contrary to the precautionary principle.
Requiring scientific consensus on an established methodology.
Correct.
Is contrary
to the precautionary principle, which underpins the EIA regulations. And both the Secretary of State and the judge erred in requiring that. It's clear from paragraph 257 of the judgment that the response to ground 3 hangs on the absence of scientific consensus. and 5. The judge further erred in holding that a qualitative assessment was, quote, consistent with the precautionary principle when the Secretary of State had herself identified what the proper precautionary approach was, and where the EIA regulations require consideration of current knowledge and methods of assessment. Second sentence of this point, at least 2 methodologies sufficiently robust despite acknowledged remaining uncertainty to be deployed by the Climate Change Committee to quantify non-CO2 emissions from the UK, and the second one by the EU to require aircraft operators to quantify and report non-CO2 effects from aircraft from January 2025. Those 2 methodologies represented current knowledge and methods of assessment. So in a nutshell, what the Secretary of State's case is, what Cagney's case is that the Secretary of State should just have required the applicant to do for non-CO2 effects what it did for socio-economic effects. Where the judge held that the lack of a settled methodology and the lack of a settled benchmark was unsurprising, but that did not prevent rational and meaningful quantification of the socio-economic benefits from the scheme. So just do for non-CO2 what you do for socio-economic. Take the same approach. Now the interested party takes a pleading point here in the skeleton. There's a short and a long answer. I'll give the short answer. The short answer to the pleading point is, if you look in the core bundle, tab 7, page 69, paragraphs 62 and 64, they articulate the ground as it is articulated in the skeleton argument.
Is that the statement of facts and grounds?
Yes,
Yeah.
Yes it is.
Good, thank you. Right, where do we go next?
We go to we go to the EIA regulations, but let me say one thing by way of preamble. The key point, or a key point that the other parties make, is that it's an exercise of evaluative judgment how an assessment is undertaken, and it's a matter of rationality, and the Secretary of State was not wrong when she had a qualitative assessment before her not to require a quantitative assessment. And my answer to that is yes, it is a matter of evaluative judgment.
And it's an irrationality check.
It is.
Right,
But
but
the extent of that evaluative judgment and the rationality of it is necessarily informed by 2 things. First thing is the EIA regulations and what they require. Second thing, the precautionary principle. So the first thing, the EIA regulations and what they require,
yeah.
Volume 1 of the authorities bundle, tab 4, page 85.
Yeah.
Regulation 14.1 sets out what an environmental statement should include, and Regulation 14.3b makes it clear that that should include information reasonably required for making a reasoned conclusion, taking into account current knowledge and methods of assessment.
Yeah.
So that's
We've
one
got the
narrow
point.
expression. And then the precautionary principle underlies the EIA directive. The court might just be happy with that, but if you need to look at Champion, it's tab 13 in the authorities bundle before you, page 354,
Yeah.
paragraph 51, where Lord Carnworth says in terms that the precautionary principle underlies the EIA directive. I don't think there's actually any disagreement about that.
No, let's move on.
And the precautionary principle does not require scientific consensus before action is taken. What it requires, and this is quite important, what the precautionary principle requires is a reasonable assessment using the best scientific evidence. And that is inherent in the precautionary principle. That's in Wyatt. Now, apologies, our skeleton says it's Afton Chemical. That's paragraph 46C. Actually, what the skeleton quotes is from the Environmental Principles Policy Statement. But Wyatt is where you get the precautionary principle.
Just give us the reference.
Yeah, so it's Wyatt. Volume 1. Wyatt, page 926 of the authorities bundle. And it's in little 9, so it's part of paragraph paragraph 9, which is a number of pages long, and it's little 9. The concept of best scientific knowledge, not a wholly freestanding requirement, separate from the precautionary principle itself. But again, I don't understand it to be, or
Can
understand
we
it
move
to
on,
be
please, because we're short of time?
Yes. The pretty unique thing about this case is that the Secretary of State herself in the decision letter identified what the proper precautionary approach should be and then failed to apply it.
Yeah. So where are you going to take us to?
So, can we go to the decision letter, Common Bundle, tab 3, page 163.
Thank you. DL 163.
Yes, so we see the beginning of non-CO2 at paragraph 174. Over the page, we see the Secretary of State diligently sets out at 175 Cagney's representations.
Right, yes.
She set them out, doesn't engage with them, but she does indeed set them out. Paragraph 176, this is the scientific consensus point that Cagney raised. And then 178 is the key bit on which we rely. The Secretary of State expresses us her disappointment that the applicant didn't take a precautionary approach and attempt to quantify the non-CO2 emissions in line with the developing guidance. Two things to say about that. First of all, said this case is pretty unique in that the Secretary of State herself has identified.
You've said that twice already.
Not just what the precautionary approach is, but what it entails.
Yeah.
Second thing, she says the precautionary approach in line with the developing guidance produced by DESNES or the DFT. But my response to that is the actual precautionary approach is also in line with the additional methodologies that Cagney brought to her attention. Because, and there seems to be a little bit of disagreement or confusion around this, the methodologies that Cagney referred to, the Climate Change Committee methodology in particular, is not a multiplier. The CCC methodology doesn't use the multiplier process. It uses a different approach. And if your lordships turn up, it's probably most easily seen in the supplementary bundle, that additional page at the very end of it. Figure 7.6.4.
I have the reference.
Yes, so it's supplementary, it should be at the very end of your supplementary bundle, or you might have it separately, my lord, because that's the little additional electronic page that we sent through. SB 307.
Yeah.
It's figure 7.6.4. And this is really quite an important figure. It was before the High Court because it explains what is going on. So the description of what this is doing makes it clear that this is both CO2 and non-CO2 increases in both the baseline and the balanced pathway. That's under description. Look at the source. The source is Professor Lee. Now, Gatwick takes a point that this is a 2020 paper. And so, I mean, there's maybe a suggestion that nothing's changed. But obviously something has changed because the Climate Change Committee has changed from not quantifying to quantifying. But also look there, there's a 2024 paper referenced, and there's CCC analysis. So there's lots of sources feeding into this.
Where's the CCC analysis?
At the very end of source.
Under notes or?
Yes.
Or no, I see
under
just
source.
two words, CCC
Yes, CCC
analysis.
analysis. So
Do we know what it is?
No.
No.
3 things are listed. Lee, Foster, CCC analysis. And from my perspective, I don't need to know really what that is. My point is that there's a methodology, it's robust, and it includes all of these 3 things. And notes, that's where you see that the methodology being used is a global warming potential methodology, looking at the last 10 to 20 years, projecting forwards, averaging out in relation to the pandemic. All of that description of the methodology shows it's not a multiplier, it's a different methodology. And then we've got the EU methodology, but I don't really need to go there in detail because I can make my point just based on the CCC methodology. Right? Here was the most up-to-date
just
science.
for my note, where's the EU methodology?
So the EU methodology, MRV, is a bit further up. It's tab 20,
Yep.
but it's appended to the CAGNY submissions. It starts at 247, SB 247.
Thank you.
Now, the judge, and this is my last point on this, the judge in Common Bundle, in his judgment, tab 10, page 288, at paragraph 258, engages with the CCC, sets out some of the material we've just looked at, but not all of it, and then draws out.
I'm so sorry. Can you give me the paragraph reference?
Yes, 258.
258.
Sort of up a bit.
Thank you.
So sets out some of what we just looked at, and then draws out what is said in box 7.6.3, which we didn't look at, but is the other reference in the CCC material.
Have we got that in the papers?
Yes.
At a different place?
Yes, it's the earlier place in the papers.
Yeah.
It's from 233 to 234.
Thank you.
And the judge draws out this line, there is large uncertainty in the warming impacts of non-CO2 effects. And my response to that is, if that's drawn out as some kind of answer to the point it is not, if that's drawn out as making some points about the cogency of the methodology or the CCC's change in position, it was not justified on the evidence. The whole point, and this point was made to the court below, is despite acknowledging this large uncertainty, the Climate Change Committee changed its position quite dramatically from Carbon Budget 6, which just talked about the uncertainty, to the Carbon Budget 7 report, which, as we've looked at, quantifies non-CO2 emissions. Not only does it quantify them, it plots them against the balanced pathway. So whatever the uncertainties that remain on a precautionary principle approach, plainly there was a methodology capable of being used to quantify the non-CO2 emissions. That's also an answer to the Secretary of State's and GAL's benchmark point, by the way. They say, oh, well, you can't quantify because there's no benchmark. First of all, as we saw with socioeconomics, don't need to agree a benchmark in order for the point to get home. But there's an obvious benchmark. We're looking at it. The CCC quantified against the balanced pathway.
I asked where the CCC advice dealing with this point was dealt. I think I've now found it. You gave me the reference 307, but in fact it's tab 19, I think. Page
Yes, I gave
233 to 235.
234.
Okay.
Yeah, sorry, I thought that's what I said.
Maybe I misheard.
So finally,
what's the key bit of those pages?
so it's box 7.6.3, non-CO2 effective aviation. It starts with quite a good definition of what they are, sets out that they likely have a high warming effect,
Yeah.
and then goes on to explain.
And what we have at page 307 is internal pagination 232, which
Yes,
follows on
follows
after
on,
234, and it is, by the time you get to the end, just above 7.6.3 on 307, that's the end of this discussion, is it? Which is why the extract stops there.
I'd have to check.
I'm going to assume that.
Yeah, I'd have to check because I just have to check that. So, one point left to make about this point. And that's what the judge said in the judgment.
Yeah.
So, we have 288, paragraph 260, that's where he says the rational response on the part of the Secretary of State to the precautionary principle. But it's really 264. But it's really 261 and then 264, where he says that the invocation of the precautionary principle goes nowhere, and that just relying on the qualitative assessment was sufficiently precautionary.
Where does it say the precautionary principle goes nowhere?
So 261, page 288.
Oh, there it is, yeah.
Yeah.
And then reads on. Yes.
Yeah. And says that it's consistent with the precautionary principle. I don't really understand how that fits with the Secretary of State having articulated what the precautionary principle actually required. So that plus the judge's reliance on scientific consensus as being the requirement. See paragraph 257, so that's slightly above on page 288, is where the judge erred. He didn't apply, and for your note, the correct approach to all of this in his analysis of socioeconomics is a little bit further up in the judgment, because it's in relation to a Barclay ground. And that's page 267, paragraphs 175 to 176. That's the right approach. Didn't take the non-CO2 arguable ground. Ground one.
Yep.
Summarised in 7 points. First, in this case, the Secretary of State fully applied the IEMA significance guidance at section 6.2 and the specific box 3 examples to come to her determination of the extent of greenhouse gas emissions amounting to a moderate adverse effect on the climate.
I think put shortly, to assess significance.
Yes. She accepted the examining authority's approach and rejected GAL's assessment of a minor adverse effect.
Yeah.
Point 2. This was a finding of a significant adverse effect, which per IEMA, as applied by the Secretary of State, means that the project followed an approach which is, quote, from IEMA, not compatible with the UK's net zero trajectory. And that's, for the reference, SB 97.
Yeah.
Third, the EIA regulations make it clear that this conclusion must be integrated into the Secretary of State's decision. Fourth, Spurrier makes it clear that in order to understand what is a material impact per the ANPS, one has to conduct a fact-finding exercise, because material impact is a question of fact and law, and the ES conclusions and IEMA are plainly material to that. They inform that understanding. Fifth, the Secretary of State's ANPS conclusion, which disagreed with the examining authority but agreed with GAL, that carbon emissions would not be so significant as to have a material impact on the ability of the government to meet its carbon budgets, was fundamentally inconsistent with her conclusions on her specific fact-finding exercise in this case. 6. While the wording of the IEMA guidance and the ANPS is different, in this specific factual context of full application of IEMA 6.3 and Box 3, they are talking about the same thing. That is what Boswell recognised.
Paragraph 70.
Yes. 7. The Secretary of State's reasons in the decision letter are wholly inadequate. They do not explain how she reached her conclusion. Indeed, 2 things. A, it took pre-action correspondence to clarify that she had concluded there was a moderate significant adverse effect applying IEMA 6.3 and Box 3. Second, absolutely none of the key answer now given by the Secretary of State to this point is in the decision letter. The key reliance on the difference between, quote, a material impact and an impact that is not compatible with the net zero trajectory because it fails fully to contribute to it, none of that is in the decision letter. Absolutely all of it is backfilling.
There's no analysis that there's a difference between the two.
No, none at all.
But maybe there doesn't have to be. That's a matter for us. Okay, let's get
Yes.
this
So we say
started.
certainly arguably there has to be, if you're going to use the 2 things together, as she does in DL 212, where she takes the 2 things together but doesn't explain why they're different.
Right.
Spurrier. The only authority I'll ask the court to go to, because Boswell the court knows very well, and we do rely on paragraph 70.
Yes.
And, well, 68 to 70.
The Spurrier is in volume 1 of the
So
authorities.
Spurrier is in volume 1 of the authorities.
Thank you. Tab or page.
At tab 19, it's at page 633. Nope, it's at page 634. So the court will recall that one of the grounds of challenge in Spurrier to the lawfulness of the ANPS was an argument that was made about the phrase material impact. The claimant in that case said material impact was ambiguous, too many shades of meaning, and that was rejected. And what the court said, kind of halfway down, rejecting that kind of close textual examination, is that it's a good example of fact and degree language.
Where are you?
So this is about halfway down, little 4,
Little 4,
at
right.
the bottom of 634. So it's little, sorry, it's not little 4, it's little 6.
Little 6
Yes, little 6.
at H.
Yes, little 6 at H, thank you. Finally, Mr. Wolf submitted. In our view, the phrase material impact is a good example of factor degree language. It cannot be divorced from or sensibly interpreted by the court in advance of the fact-finding exercise, which in this case will have to be carried out by the examining panel and the Secretary of State on the DCO application. I rely really strongly on that, because I say when you're understanding what material impact means, that shows that the correct approach is you have to take into account that fact-finding exercise. That includes the environmental statement, that includes the IEMA guidance and how it's applied, that includes the conclusion reached in relation to the IEMA guidance, and that includes the fact that that conclusion was that the project is not compatible with the UK's net zero trajectory.
Basically, this is an irrationality challenge on an inconsistency, internal inconsistency in the reasoning.
Yes.
We don't need Spurrier for that.
No.
Let's get straight to the point.
Well, we do need
We
Spurrier.
are short of time. Let's get straight to the point.
Well, that's the ground, my lord. And the judge in the judgment, common bundle, tab 10, page 274. Says a couple of things I'll pick up. 2. First, page 2, paragraph 200, in response to that emphasis about the decision to apply fully IEMA guidance in box 3. And the judge's response to that, though, it's a guide. It just informs the application of policy. And my response is, well, that's right. But in these circumstances, when IEMA is used in this way, it leads to the error that your lordship articulated. Second,
Yeah.
the judge does a lot of the backfilling that I just described. 2 good examples, as we're short of time. 276, paragraph 210.
210, right.
Yeah. I'll just give that one example. But there's a lot of backfilling in that.
So what's the example in 210?
So 210, he says in the middle of that paragraph, her judgment that the proposed development is compatible with the net zero strategy and can be managed within the government's overall strategy for meeting the net zero relevant carbon budgets doesn't contradict her finding that by virtue of its scale, the scale of its effects, the project will fall short of fully contributing to the UK's trajectory towards net zero. It's a broad judgment, blah, 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 blah. All of that, effectively, is explaining an inconsistency in the Secretary of State's approach, where in one paragraph she says, project is not fully compatible with the net zero trajectory. Indeed, it is. And then in another paragraph says that it's compatible with the jet zero trajectory. So I'm taking this very quickly, which is not wholly conducive to the
Well, yes, but if you cut out the repetition and the unnecessary submissions, you would still cover the ground effectively.
Yes, well, I'm very grateful. My Lord, I want to leave some time for Ms. Lane to cover ground 7. So the final thing I'll say in relation to this...
Sorry, after you, I beg your pardon.
No, my Lord, please.
No,
Your concerns are...
No, please go ahead.
The key point that I just want to respond to from the parties' officers is Secretary of State skeleton, page 10, paragraph 22b.
Yep.
No, it's not. It's page 9, paragraph 20C.
The Secretary of State skeleton.
Yes, the Secretary of State skeleton, page 9, paragraph 20C.
I have that on page 8.
Oh, okay.
It's on my.
No, it's 9, page 9. So 20 is on page 8, but page...
It must be my fault. 20.
Little c. It's just above 21. Where the,
sorry, it's my fault. I beg your pardon.
where the Secretary of State criticises Cagney for relying on the term incompatible. And she says that Secretary of State doesn't use the term incompatible. And my response to that is twofold. First of all, it's not Cagney that uses the term incompatible, it's IEMA. That is, and I'm not going to ask the court to look at it, but SB 97, the key paragraph below the diagram, not compatible with, which we take to mean incompatible. And second, the Secretary of State does not resile from the clarification she gave in her PAP letter that she fully applied IEMA 6.2 and the box 3 examples. And in those circumstances, my submission is the error of logic arises in that there's an inconsistency between that and the ANPS conclusion, my lord, unless there are any...
For my part, that's very clearly set out in the skeleton. We understand exactly what you're saying.
My lord, I'm grateful. My lord, I understand that ground 10 might take... ground 10.
7.
Ground 7 might take 10 minutes.
That's wonderful. Thank you.
I'm very grateful.
Yes, thank you very much, Dr. May.
Thank you. So, my lords, the core of Cagney's case under this ground is quite simple. It's set out in our grounds of appeal, and in essence, it turns on this. It was agreed by the Secretary of State in granting the DCO and by the judge below that a requirement was necessary to address the risk of wastewater from the expanded airport being discharged into the Crawley sewage treatment works without Thames Water having first confirmed that its infrastructure there was adequate to receive that wastewater. And our case is that requirement 31.9, as drafted, is simply not adequate to meet the objection that it was imposed to overcome, and that's for 2 reasons. The first, because it only requires an on-site wastewater treatment works to be physically complete and a permit to have been applied for to the Environment Agency before dual runway operations commence, and not that a permit actually be granted or that the treatment works be actually operational. And second, because it contains a tailpiece which would allow for some alternative unexamined solution, which was not before the Secretary of State, to be agreed between Gatwick Airport and Thames Water outside of the statutory process. And I'll refer to those as the Leeds City Council error and the Mid-Counties error. I don't propose to take the court to the legal principles in the authorities bundle because they're agreed. They're at paragraphs 79 and 80 of our skeleton argument at page 21. They're also set out at paragraph 56 of the Secretary of State's skeleton argument at page 22, and we don't dispute anything that's in that paragraph.
Thank you.
So I'll start with what I'll call the Leeds City Council error on the wording of the requirement proper. And just for your lordship's note, the key paragraph in Leeds City Council itself is paragraph 35. It's authorities bundle 1, tab 10, page 273. And in essence, what it says is that where a decision maker considers that a condition is necessary to meet an objection to permission, she must satisfy herself to a standard of rationality that the requirement or condition imposed is adequate to meet that objection. And a quick roadmap of where I'm going with this part of the ground. First, I just want to touch on what the underlying objection was that requirement 31.9 was seeking to address. Then we'll have a look at the actual wording of 31.9 itself and how it purported to meet that objection, and then why we say that it doesn't meet that objection to a standard of rationality, and why the decision letter doesn't cure the error. So the objection that the requirement was imposed to meet was in relation to the very large increase in volumes of wastewater that were proposed to be created by the development. Again, I'm conscious of time. The figures are set out in paragraph 82 in our skeleton. The underlying document that they're drawn from is the airport's relevant representations report. That's at supplementary bundle tab 11, page 146, which was where at the outset of the examination, Gatwick modelled that the development would increase daily volumes of wastewater by 67.5% on a dry day and 16.7% on a wet day. My Lord Holgate, I can see, is turning to that page in the supplementary bundle. So if we...
No, I'm looking at something else, the skeleton, but where it's very helpfully set out.
I see. So, yes, so at the time it was anticipated that that additional volume would be discharged to the Crawley sewage treatment works. By the time of the decision, however, in September of 2025, Thames Water hadn't carried out the modelling necessary to establish that it could.
And the modelling couldn't be done by the time of the decision.
No, and indeed it still hasn't been done, my Lord. And so we still don't have that certainty. So, notwithstanding the absence of modelling, Gatwick themselves suggested throughout the examination that no requirement was necessary. We can see that in the Minded 2 letter. Again, we don't need to go there, but it's paragraph 209, Common Bundle, tab 2, page 149, in which the Secretary of State recorded that the airport didn't consider that any kind of requirement was necessary to address this risk. But we can tell from the fact that a requirement is included in the final DCO that the Secretary of State disagreed, that she considered that one was.
Well, she required more information, didn't she?
She did, yes,
Yeah.
my Lord. Yes, so she in essence, the very fact of the existence of the condition, it's the requirement, the requirement test is safe as conditions test. Clearly, the Secretary of State concluded a requirement here was necessary. And Mr. Justice Mould agreed with that in the court below, so if we could just turn to this part of his judgment. So this is Common Bundle, tab 10, page 311, is where this...
Sorry, what paragraph?
So paragraph 335, no, 353, yes, 353, page 311. And so at this paragraph, Mr. Justice Mould mentions the Cagney talking about not disagreeing with the need for effective controls to ensure that the additional water flows from the operation of the development will be accommodated by Thames Water, existing infrastructure, or through the provision of work number 44, that's the on-site treatment works. Over the page at 357, the final sentence of that paragraph, he concluded that it was obviously necessary for appropriate arrangements to be made to manage that uncertainty and to avoid a future state of affairs in which Thames Water's wastewater infrastructure provided insufficient capacity to accommodate the proposed development. So he was alive to that risk. And then at paragraph 359, he stated that in the language of 35 of Leeds City Council, the particular objection which was to be met by the imposition of the requirement 31.9 was the risk that following completion of the ongoing modelling work, Thames Water's existing infrastructure would be found to lack sufficient capacity to accommodate the additional flows. It would be objectionable for the proposed development to begin operations in such circumstances. So we can see there that Mr. Justice Mould agreed with the Secretary of State that there was an obvious objection here that a requirement was necessary in order to meet. And if we could now go to the wording of the requirement itself, which is Common Bundle, tab 4, page 198 is where
Well, it's actually set out as we're at the judgment. It's actually set out in the judgment.
Ah, yes, it is. We can stay there then.
Which
Yes,
I
so
think might save us navigating around.
Yes, so the requirement...
351?
Yes. So the requirement itself sets out that work number 44, or the development must not commence until either work number 44 has been completed and an application has been submitted for an environmental permit to the Environment Agency for its operation, or until Thames Water Utilities Limited confirms that its infrastructure will be able to accommodate additional flows, unless otherwise agreed in writing by Thames Water Utilities Limited. So the core of Cagney's complaint is that as just a matter of ordinary language, this requirement only requires the physical completion of the wastewater treatment works on site and the submission of a permit to the Environment Agency before the commencement of dual-runway operations. It doesn't require that the treatment works be operational, nor that a permit be granted, nor for it to continue to be operational if it later becomes more convenient for Gatwick to dispose of wastewater in a different way. And as I've already touched upon, it was disposing of it in a different way was in fact GAL's preferred approach throughout the examination and right up to the Minded 2 decision. And that's why we say essentially that the wording of this requirement is irrational in the Leeds City Council sense. It just simply fails to meet the objection that it was imposed to address. It doesn't provide adequate control to ensure that wastewater will be discharged to a system that may not be able to cope with it. And in his judgment, Mr. Justice Mould focused on the fact that the requirement would ensure that dual runway operations couldn't commence until additional infrastructure was in place on site. That's paragraph 358 in the judgment, where he said that the evident purpose of the requirement was that the works authorised by the DCO to provide additional capacity at the airport should have been completed prior to the commencement of dual runway operations. But we say that essentially aligns the physical works with the underlying harm that they are designed to address. And that there's a difference between something being physically in existence and something operating as intended to solve the problem. And that the requirement, it secures the former but not the latter in this case. Finally, just on the Leeds City Council error, at paragraph 362 of the judgment, so this is, we're still in the same place, but it's over the page at page 313, the judge addressed in this paragraph the risks that having completed the construction of the treatment works, Gatwick then declined to bring it into use. This is a point raised by Cagney in the examination. Or that the Environment Agency could decline to issue a permit. And he said that it was rational for the Secretary of State to take the view that neither of those risks was sufficient to warrant any amendment to the terms of the requirement. But the Secretary of State doesn't say that. She doesn't address those risks specifically in paragraph 266 of her decision letter, which is quoted at paragraph 361 of the judgment. She says that she noted the representation made by Cagney on the 9th of June that wastewater treatment should be fully operational prior to dual runway operations, but she was content that in the event an on-site wastewater treatment works is needed, the timescales included within the requirement wording allowed sufficient period for the Environment Agency to consider potential impacts and receiving water course and set appropriate permit limits. And she also noted that the matter of wastewater had been agreed between the applicant and the Environment Agency in their statement of common ground. And she reported that this was the Environment Agency's preferred approach and that they didn't foresee an issue. Therefore, she was satisfied that the outstanding concerns had been addressed. So this paragraph, it talks about timescales and it talks about the requirement being agreed, but neither of those points go directly to the fact that the requirement itself doesn't secure that a permit is actually granted, and it doesn't secure that that the treatment works be operational. The fact that it's been agreed is, we say, simply not relevant to whether or not, as a matter of law, the requirement operates as intended. The standard in Leeds City Council is not whether an adverse outcome is likely if a requirement is breached, but whether the requirement itself is adequate to meet that objection. And whether or not a developer might probably comply voluntarily is not a substitute for an enforceable requirement. And then the judge did go on to consider the risk of Gatwick abandoning the treatment works at a later date. There might be all sorts of unforeseeable reasons why Gatwick might choose to prefer to discharge in another way subsequently, having constructed the wastewater treatment works. It might turn out to be more expensive to operate the on-site works. They could break down. It might be another more profitable use of the land might be found. The problem is that without an effective requirement, the DCO fails to avoid this key risk that the judge himself and the Secretary of State herself had identified regarding discharge into Thames Water's assets. So unless your lordships have questions on the Leeds City Council error, I'll move on to the tail piece.
Thank you.
So again, just for your lordship's notes, the key paragraph of mid-counties itself is paragraph 70. It's authorities bundle 1, tab 9.
Again, the judge set it out at 363.
Yes. So essentially, yes. So the principle being that parties shouldn't be able to agree to something that's very different in scale and impact from what has been permitted outside of the statutory process. And here we say that...
Was that the case where the condition restrained floor space for retail purposes?
Yes, my lord.
So the effect of the tailpiece was that they could agree, without going through the statutory process, something very much bigger.
Indeed, yes.
And the tailpiece didn't really impose a limit
No.
on what they could do under that mechanism.
Yes.
My lord, it's warming to the theme of his submissions in that case.
Yes. So, and essentially, our point on this is simple, but we say with a clear prospect of success, which is that there are similarly here. This allows for a potentially very different solution to be privately agreed between Gatwick and Thames Water, a statutory undertaker, which was not examined, which did not form part of the Secretary of State's decision. And there could be this other entirely unassessed option, and we say that's unlawful. Now, the judge at paragraph 364, which is it's page 314, it's a very final page of the judgment, simply stated that he does not accept this argument, and he said that read in context, the tailpiece does no more than provide an element of flexibility in enabling Thames Water as a statutory undertaker to give its agreement to alternative means of achieving the evident purpose for which it has been imposed. But in my submission, that's simply not the case. The requirement doesn't purport to limit what else could be agreed.
I think one of the points that's taken against you, I'm sorry to talk across, but I just think we need to welcome your answer to this, because one of the points I think that is taken against you is that there is a specific requirement in 1.4 the DCO, which says, where it says, I'm sure you know, but I mean, where it says unless otherwise agreed, that can only be agreed within the envelope of the environmental statement.
My lord, yes. So CAGNY actually answered this point in its deadline 9 submissions, and if we could go there, so it's supplementary bundle, tab 16, page 206.
Hold on. Yes, 206.
206, yes. So this was CAGNY's final sort of closing statement, deadline 9 submissions. And CAGNY addressed in those submissions this specific point and said that, in essence, that doesn't provide a satisfactory answer in circumstances where, and I'm not quoting directly, I'm paraphrasing, but in circumstances where the requirement for consent is with Thames Water rather than with a local planning authority. The point made here is that a local planning authority is well placed to be able to assess EIA effects in the round, but a statutory undertaker, that's simply not its purpose. And I might add now that it's not the regulator either that's in this tailpiece. It's not unless otherwise agreed with the Environment Agency, who again would be better placed to potentially make that assessment in the round. This is a private applicant for permission being allowed to agree with a sewerage undertaker some other solution. So first, we say that Thames Water simply can't be expected to carry out that detailed assessment. And if I can be glib just for a moment, it hasn't even managed to model the capacity of its own infrastructure yet. So it's a lot to put on the undertaker. And then the second response to that, which is also touched on in our deadline 9 submissions, but that's that it, just as a matter of law and principle, that doesn't prevent the reaching of an agreement in private out with the statutory process. And it undermines the importance of public participation in the DCO process and the environmental impact assessment process in particular. And if I could just take your lordships to just one authority, which is Hubert and Carmarthenshire. So it's the first volume of the authorities bundle. It's tab 14, and it starts the passage I'm looking at page 370.
That was volume...
Sorry, volume 1.
Thank you.
Tab 14. page 370. And apologies, I realise I sidelined the wrong paragraphs here when I was doing the authorities bundle. But so paragraph 33 at the bottom of that page, in this case, Sir Ross Cranston said that applying the Mid-Counties principle to this case, you can see at 33 he was applying the Mid-Counties principle, and then over the page at paragraph 34, crucial paragraph, he said it would be quite wrong for the Planning Commission here, having been subject to public debate and democratic decision-making in the Council, to be capable of being sidestepped by the use of the tailpiece, and therefore he found that the tailpiece, in that case, must be severed. And we say that's exact kind of sidestepping is what this tailpiece potentially leaves.
So what was the
room
relief
for.
in that case then, that the tailpiece was effectively blue pencil from the condition?
Yes, so your lordship is once again ahead of me, because the last thing I was going to say is a couple of words on relief. So in that case, the relief was that the tailpiece must be severed. Relief was canvassed before Mr Justice Moll briefly in oral submissions in the High Court, and it was sort of generally concluded, I think fair to say agreed, that had an error of law been found by him in relation to this ground alone and no others, that it would be appropriate to have some kind of hearing to consider the matter of relief. In the tailpiece cases, the relief has tended to be the severing of the tailpiece. Obviously, the matter might be different if a court were to determine that the underlying requirement wording was flawed in some way, the Leeds City Council error, as it were.
Yes.
So there's two distinct potential kind of routes here on relief, but certainly, I think it's safe to say that if a court were to conclude that the only legal error was just this tailpiece, I don't think we could seriously suggest that the Commission should be quashed in those circumstances, and excising the tailpiece would presumably be appropriate. Or a mandatory order, indeed, yes. Yes. So, yes, so just essentially, I think your lordships have the point, but we just say that clearly this requirement was felt to be necessary, and we, just as a matter of ordinary language, it doesn't control for the risk that the local communities were clearly very concerned about throughout the examination. And then, unless I can assist the court further.
Could I just ask, I'll draw attention to, I think it's on page 195 of the Common Bundle.
My lord, yes.
It's, I'm not sure I got the right reference. It's Schedule 2, I think, paragraph 1.4.
Yes.
It explains what is meant by otherwise agreed by a discharging authority, and has a long list of provisions, including 31, and then, as my lord pointed out, it refers to the environmental assessment envelope, if you like.
Yes.
Discharging authority, is that defined somewhere? What we seem to have is a whole collection of provisions which won't just involve Thames Water, but will be...
No, so I will
doesn't matter
check
hugely.
this, my lord, but I believe that in all... No, I can't necessarily say that in all the other cases it's the local authority.
Well, I was going to say, it wouldn't necessarily be the local authority.
No, but certainly what I can say is that all of these requirements that are cross-referred to have various tailpieces with discharging authorities. I'm not aware of there being any definition.
There isn't.
I'm being told there is a definition.
In the response from the Secretary of State's skeleton, they've appended the relevant provisions from the DCO, and there is a definitions or an interpretation clause which does not include the definition of a discharging authority.
One other thing just to say perhaps on this paragraph is that the specific requirement we're dealing with was added to this paragraph via a corrections order that came in fact, during the High Court hearing.
Yeah.
So it wasn't in the original version of the DCO, but now it is.
I suspect this sort of drafting may have been influenced by the practice of those who do parliamentary work.
Quite possibly, my lord. But I think our answer to that point remains that we just say that Thames Water, as the, well, for all intents and purposes, discharging, or shouldn't be a discharging authority, and for all intents and purposes is being put in that position, but it's not really qualified to perform
Thank you.
My Lords.
Thank you very much. Sorry.
My lord, you asked for some references in relation to ground four.
Yes, you did. Right. Yes, thank you.
I mean, we can do this in writing, or if it's easier.
Whichever is more convenient.
Or I can, but it's all the references where we said in our skeleton about the Secretary of State's making the point under ground four that it was not appropriate to consider the data, or it's not a matter for them, and then the Secretary
This is
of
the
State's.
global point.
Yeah.
And that's in the skeleton.
Yeah, so there's a
I
CA
think
skeleton,
what we
a
were
High
looking-
Court skeleton, and a High Court reply for us, and then there's Jessica Matthews' witness statement. for
Anything
High
in the statement of facts and grounds?
It's in the reply. It's in the reply.
But nothing in the statement of facts and grounds.
Well, we hadn't heard the Secretary of State's response by then.
No.
It's in the reply.
Well, I think it sounds like there's a long list of
There
references.
is. We'll
Let's
write
have it on paper.
Yes, we'll write it down. Thank you.
Yes. And then come back early. Yeah. Perhaps it would be better to have a clean start.
Yes, my lord, I'm very happy to do that. With
We come back a little earlier.
That should be fine. I hesitate because
Yeah.
you may not be aware, my lords, but the reason I wasn't at the High Court hearing is because I had a baby.
Ah.
Said baby is coming to chambers because she needs to be fed.
Yeah.
And I did tell my mum to come at 1:10 but knowing my mum, she's probably already there.
So what would you suggest? We do?
So I'm very happy to start.
Sorry, you have to
Wednesday.
mention this.
I'm very happy to start. I think 10 minutes early will be fine. But
which
or
would
if
you
we could
prefer?
start at 2, because I think I can be quicker than I'd anticipated.
Okay, let's.
In assisting you, given what we've heard
Or we
today.
can, and if necessary, we can, if everybody's happy, and we haven't quite completed tack on, like we did yesterday, a little time to the end of the day.
Yeah, that's possible. But I'm expecting, based on today, that I can probably be relatively swift with a couple of things and a bit longer with something else, and that should all balance itself out.
So 2 o'clock.
2 o'clock.
Okay. Thank you very much.
We'll rise the table.